Hello, my name is Vedant. I am a legal intern with LEXIS and Company. Before starting of the video, I would like to say that please like and share the video and subscribe to the YouTube channel of LEXIS and Company. There is a small disclaimer that the videos of this channel does not promote or advertise anything about the LEXIS and Company, and these videos are only for educational purposes as per the guideline of Bar Council of India. We have to give this disclaimer. So, the topic of the video is recently the Guwahati High Court in a judgment reiterated that to prove guilty of an accused, it is not the for the it is for the prosecution not only to prove the circumstances but also to prove the complete chain of event leading to the guilt or leading to the accusation. So the Guwahati High Court recently, comprising of bench of Justice Manesh Ranjan Pathak and Justice Mir Alfaz Ali, observed that to prove the guilt of accused, prosecution is required not only to prove the circumstances but also to prove the complete chain of events. This was held in case of Mohammad Zakir Hussain versus the state of Assam and another. So, what were the facts of the case? The facts of the case were the appeal has been filed against the judgment and order of conviction and sentence which was passed by the learned additional additional sessions judge, whereby the appellants was convicted under section 302 slash read with section 34 of the IPC and was sentenced to suffer rigorous imprisonment of life and with fine of and default of rigorous imprisonment for further 1 month each. The facts of the case that led to the conviction are an ijahar was lodged by Nayyab Ali, wherein it was stated that one day his son Hussain Ali left his house on a bicycle along with rupees 3,000 to purchase Godrej Almira, but did not return home that night and went missing. Next day, his dead body was found with a severed head, and the money and phone were missing. In Nijahar, the informant stated that he suspected Zakir Hussain, Zubair Rahman, and Babul Ali, son of Abdul Hussain, as the persons involved in murdering his son, as those persons resided near his house and had been as laborers along working as laborers along with his son for the last 4.5 months, and his son and said his son used to spend his leisure time with them. During the course of the investigation, all relevant steps were taken by the investigative officer. The three accused were then apprehended and arrested, and their statements were recorded. Since no such incriminating materials were found against the alleged arrested accused Babul Ali and Halima Khatun, they were not sent up for trial. The learned trial judge, after completion of recording of evidence of prosecution witness, recorded the statement of the accused appellant under section 313 CRPC. During the cross-examination, it was contended that the accused Zakir told police that he had killed Hussain Ali 1 or 2 days before he led police to the recovery of lathi used in the incident. So the witnesses during the cross-examination specified that the accused Zakir has agreed and confessed to the crime. Later, Dr. Gopendra Mohan Das, the autopsy doctor who conducted the post-mortem examination of the deceased Hussain Ali, during the record of his evidence in chief, disposed before the learned trial court that the deceased was a mate of 23 years of age. During such examination, he found the following injuries: that the head was severed by a sharp object. He also disposed that, as per his opinion, the cause of the death of the deceased was due to hemorrhage and shock sustained by him as a result of amputation, a head cut injury over the neck. So, what were the contentions of the party? Learned counsels for the appellant submitted that as the prosecution had failed to prove the guilt of the accused person beyond a reasonable doubt and the required completion of each chain, they are entitled for acquittal in the case. It was also placed before the court that the accused persons made their statements being in police custody regarding commission of the crime. The same cannot be considered in evidence against them as to punish them under section 302 IPC. With regard to the statement made by the accused Zakir Hussain, before police in the police station with regard to the recovery of arm allegedly used in the commission of the crime. It was submitted that the said disclosure of statement by of the accused Shakir cannot be valid piece of evidence as to prove guilt of the accused persons in the case. It is also submitted by the learned counsel for the appellant that the weapon seized, though stated to have the blood stain, was not forwarded to the FSL for its necessary examination, and as the prosecution failed to do the same, said do said same seized by the police cannot be used to have been during commission of the crime by the accused person. On the other hand, learned counsel for the prosecution for the state of Assam fairly submitted that the confessional statement made by the accused person before police, even in the presence of other witnesses, cannot be entertained as a valid piece of evidence to prove the guilty of the accused person. So, what were the observations and judgment of the court? The court observed that, however, marshalling the evidence of prosecution witness one, we have seen that the informant, prosecution witness one, father of the deceased, in his evidence before the learned trial court as well as in the FIR filed in the case, did not state that the accused Akas Ali had called his son away around 6 p.m. on the previous evening of 6 April 2013. Rather, the informant, prosecution witness one, father of the deceased, in his evidence before the learned trial magistrate as well as in his written statement, clearly stated that on the evening of 5th April 2013, around 7 p.m., his son left his house in his bicycle with 3,000 rupees and the mobile phone to purchase Godrej Almira from Borghiolu. Though the death of the deceased was homicidal in nature and gruesome, there was no eyewitness to the incident, and the prosecution is required to prove the guilt of the accused on the basis of circumstantial evidence beyond a reasonable doubt. The High Court, acquitting the appellant, noted, to prove the guilty of the accused person in a case on the basis of circumstantial evidence, the prosecution is required to not only prove the circumstances but also to complete chain of circumstances on the basis of which the guilt of the accused can be established. But in the present case, prosecution has failed to complete the chain of events and the evidence so as to prove the guilt of the accused beyond all reasonable doubt, and the said chain of evidence remained incomplete. For the reasons, we are of the court is of the opinion that due to lack of non-compliance or non-completion of chain of evidence and circumstances, the impinged judgment and the order of conviction and sentence dated 20 April 2016 passed by the learned additional session judge Tejpur cannot sustain, and accordingly we set aside the High Court set aside and caused the judgment and order of conviction and sentence. Accordingly, the High Court allowed the three appeals and acquitted the appellant from all charges leveled against them. So this was the observations and judgment of the Assam High Court in the present case. Thank you. Do like and share the video and subscribe to the YouTube channel of Lexis and Company.